All right, so what's going on? This is Instructor Mike. All right, so without further delay, I'm going to go on ahead and just dive right in. One of the things that I find to be ironic is by now you've probably heard about the situation that happened with Tyre Nichols in Memphis, Tennessee, and how he lost his life at the hands of, guess what, five black police officers, right? So I just felt it appropriate to just go on ahead and just dive right in to one of the pivotal cases that law enforcement learns when they go to the police academy. And that case is right out of Memphis, Tennessee. Tennessee versus Garner, 471 US 1, 1985. And that case talks about the use of force. We're going to find out exactly what it is. I've been the type of person where I've always talked about police training. And this is one of those cases that you might find in a particular police academy, in service, where they go through talking about Tennessee versus Gardner all the time. So let's go on ahead and go through it, okay? And looking at Tennessee versus Gardner, I'm actually going to take myself out of it. And looking at Tennessee versus Gardner, we gone ahead and look at, I'm sorry, let me get to that screen. Here we go. And looking at Tennessee versus Gardner, okay? Let's look at the case history. Right out of Memphis, Tennessee at approximately 10:45 p.m. on October 3, 1974, Memphis police officer Elton Hyman and Leslie Wright were dispatched to a Prowler inside call. Upon arrival, a woman on a neighboring house motioned towards the house next door. Wright radioed their on-scene arrival while Hyman went behind the house and he hears the door slam and saw someone run across the backyard. That someone was Edward Garner, a teenage male, about 5'5" to 5'7", approximately 145 pounds. This was according to the testimony of Elton Hyman. Hyman, with the aid of a flashlight, said that he was able to see Garner's face and hands, saw no sight of a weapon, and though not certain, he was reasonably assured that he was unarmed. All right, here we go. Garner crouches at the fence, and you all who are already thinking about it, you're thinking he's probably about to hop that fence. He doesn't want to get caught. That is exactly what Hyman thought, and he shouted, "Police, halt!" Takes a few steps towards him. Garner begins to climb the fence. Hyman believes that if Garner makes it over the fence, he will get away, and that is exactly what he thought. Hyman shoots, and Garner is hit in the back of the head. He is subsequently transported to the hospital where he succumbs to his injuries in surgery. On his person, $10 in a purse is found on his body, and these were found to be items that were taken from the house. Okay. So when the case went to, review, the statute that Hyman relied on, as well as the city of Memphis, the state of Tennessee, was Tennessee Annotated Code 40-7-108. And it states that if, after notice of the intention to arrest, he either flees or forcibly resists, the officer may use all necessary means to effect the arrest. Memphis Police Department, they were slightly restrictive on that statute, but they still allowed the use of deadly force in cases of burglary. All right. So here's the case history. The incident was reviewed by the Memphis Police Firearms Review Board and sent to a Shelby County grand jury. What do you think they did? Nothing happened. Neither took action. Okay. So the father, typically, what do you see in these cases? Typically, you see a lawsuit to follow, and that is exactly what happened. So not Eric Garner, Garner's father brought suit in the United States District Court for the Western District of Tennessee, seeking damages under Title 42 United States Code Section 1983 for asserted violations of Garner's constitutional rights. So when the court got it all the way to the Supreme Court, this is a United States Supreme Court case. By the time the United States Supreme Court got it, this is the analysis, okay? One, whenever an officer restrains the freedom of a person to walk away. He, being the officer, has seized that person. And this is according to United States versus Brignoni Ponce 440, 422 US 873. Okay. This is a 1975 Supreme Court case. While it is not always clear just when minimal police interference becomes a seizure, according to U.S. versus Mendenhall, 446 U.S. 544, 1980, there can be no question that apprehension by the use of deadly force is a seizure subject to the reasonableness requirement of the Fourth Amendment. Those of you all who follow me, you know, you've heard me talk about the differences between when a civilian uses deadly force and them walking up towards the body versus when the police use deadly force, them walking up towards the body. There is a Fourth Amendment inquiry that comes when the police uses deadly force versus when an average citizen uses deadly force. Okay. And here you just heard me cite the Supreme Court's analysis as to the reasonableness inquiry that must take place for every police officer's use of deadly force that in fact does result in the person being killed. Okay. Next, a police officer may arrest a person if he has probable cause to believe that the person committed a crime. This is according to United States versus Watson, 423 U.S. 411, 1976. To determine the constitutionality of a seizure, we, being the United States Supreme Court, must balance. Remember, I said there's a balancing test. They must balance the nature and quality of the intrusion on the individual's Fourth Amendment interest against the importance of the governmental interest alleged to justify the intrusion. And here is the case on that. United States versus Place, 462 U.S. 696. That's a 1983 case. That case happened before the Garner case, not before the situation, but after this came to oral arguments. The dissent, in other words, the plaintiffs, the state of Tennessee, right? They're arguing that the shooting was justified by the fact that Officer Hyman had probable cause to believe that Garner had committed a nighttime burglary. The Supreme Court didn't agree. Okay. The Supreme Court stated that while we agree that burglary is a serious crime, we cannot agree that it is so dangerous as to automatically justify the use of deadly force. So for those of you all who've been in my firearms classes, concealed carry, security, whatever the case may be, think about what the Supreme Court just said. We agree that while burglary is a serious crime, we cannot agree that it is so dangerous as to automatically justify the use of deadly force, right? So if they're putting that type of cap on the police, what does that say for you as a citizen, as a civilian? Just think about that. Here we go. The FBI even classifies burglary as a property crime rather than a violent crime. And of course, they cite the Federal Bureau of Investigation Uniform Crime Reports. During this time, it was 1984. They updated all the time. So make sure you check on the FBI website, okay? Although the armed burglar would present a different situation, the fact that an unarmed suspect has broken into a dwelling at night does not automatically mean he is physically dangerous. And this case demonstrates as much, right? Of course, they cite the other case that also has that theory or the holding in the court, Solemn versus Helm, 463 U.S. 277, 1983. And of course, there's other citations with that too. In fact, the available statistics demonstrate that burglaries only rarely involve physical violence during the 10-year period from 1973 to 82, which was the time period where this happened. Only 3.8% of all burglaries involved violent crime. The holding in Tennessee versus Garner, 471 U.S. 1, 1985. The holding, which is the decision by the court, It was a 6-3 decision. The Tennessee statute is unconstitutional insofar as it authorizes the use of deadly force against, as in this case, an apparently unarmed, non dangerous, fleeing suspect. So when we get to the analysis of Tyre Nichols, think about it, right? An unarmed, non dangerous, fleeing suspect. Such force may not be used unless necessary to prevent the escape, and which means you have to have the other part too. The officer has probable cause to believe, not reasonable suspicion under Terry versus Ohio. That's another U.S. Supreme Court case. Terry versus Ohio, 392 U.S. 1, right? Probable cause to believe that the suspect poses a significant threat of death or serious physical injury to the officer or others. So when we look at the case of Tyre Nichols versus Memphis Police Department, here's the case analysis. Tyre Nichols was stopped at approximately 8:24 p.m. on January 7, 2023, near the intersection of East Rains Road and Ross Road in Memphis, Tennessee. The Memphis Police Department initially stated on January 8th that the traffic stop of Nichols was due to alleged reckless driving. On January 27th, Memphis Police Chief Saralyn or CJ Davis stated that her department reviewed the footage, including the body cameras, to determine what probable cause was, and we have not been able to substantiate that. It doesn't mean that something didn't happen. There just isn't any proof. And this was according to Police Chief CJ Davis. So let's look at reckless driving. According to the Tennessee Title 55, Chapter 10, Section 205, what is reckless driving? Do you think reckless driving is a felony or a misdemeanor? Well, according to this code, a conviction for reckless driving will result in 6 points assessed against your driving record. Additionally, you can face up to 6 months in jail and a fine up to $500. My criminal justice students, anything that results in a penalty of up to 364 days in a city or county jail and a fine assessed of close to $1,000, if not maybe $1,500, what is that? You guessed it. That is a misdemeanor. And a felony is a crime where the sentence imposed ranges all the way up to 1 year, up to life in prison without the possibility of parole, or in those states applicable, death. That is a felony. It's not necessarily the severity of the crime, even though it is. It's the sentence you can be sentenced to. Okay? So reckless driving is a Class B misdemeanor. Was this case exigent or that emergency field where they just had to chase after him? Remember the case of Tennessee versus Garner. What did the Supreme Court hold? You can't use deadly force towards someone, right? Non-violent, not posing a significant threat to you, and not posing a significant threat to anyone else. You don't even have probable cause to believe that he's going to do that. It's reckless driving. And we're not trying to say reckless driving isn't serious, but did it warrant that? I would argue it did not. But let's look at Memphis Police Department policy as it relates to the use of chemical irritants. We won't even get into tasers and batons because you already understand where it's going, right? Rules on chemical irritants, agents, the response to resistance. Chemical irritant agents will continue to be used in the force continuum between verbal commands and physical confrontation because the use of this tool is an escalation of the force continuum, and this is their policy. Officers must exhaust all verbal means to control a subject prior to chemical irritant agent application. Did they do that? Let's continue. This is the last slide. Although the use of chemical irritant agent is not an actual hands-on contact with the subject, officers must still adhere to all the provisions regarding a response to resistance as listed in the Memphis Police Department Policy and Procedures Manual and as governed by state statute. The officer must perceive a quote credible close quote physical threat to his or to him or to her, the subject's or another person's safety prior to the application of a chemical irritant agent. A credible physical threat to the officer, the subject, or another person must include some type of overt action by the subject. What are your thoughts? What are your thoughts on what we just talked about? How ironic is it that we have a use of force case like this that has gotten the headlines in the same city and state where one of the cases, the many cases that we're taught in the police academy, just so happens to be, you know about the Fourth Amendment, but you know about Tennessee versus Garner and Graham versus Conner. Come on. What are your thoughts? Sound off in the comments. All right, this is Instructor Mike. You've been trained. Don't forget to follow me on Facebook at Mike Brown or Instructor Mike. Follow me on Instagram, TikTok, and Yes Mike Said It, on Twitter at Instructor Mike 1, and subscribe to my YouTube page, Instructor Mike. Hit the subscribe button, hit the bell for notifications. Get your butt in someone's concealed carry class. It's no one's job to protect you but you. I'll see ya.